So we have to decide if that is legal. And what is legal? That you are charging for vicarious criminal liability against the partners without arraigning the company. So is that legal? As per the passage, first of all, we have to decide yes or no. The answer is no. And why? Because as per the passage, it is given that the existence of section 66 is a clear pointer to the fact that criminal prosecution cannot proceed against partners without arraigning the firm as an accused. So you have to first arraign the firm as an accused, only then you can proceed with this. So in this case, they are not doing that. Therefore, the correct answer is D. Okay, decide. So the public is thus demanding that the partners and persons in charge be convicted as per the rule of vicarious criminal liability. Can they do that? No. Why? In the passage, it is given that the principle of vicarious liability to criminal law, there is no such concept of vicarious liability. It would be applicable only if there is a statute. Now that statute, as per the passage, is given in food and safety standards. But here in manufacturing, we don't know whether that has been given or not. Right? So as a concept, it is given in the passage that vicarious liability to criminal law does not apply. Right? It only applies when there's a statute to that effect. In this scenario, that is not given to us. And therefore, the answer would be A. Okay. Can SU key Q be prosecuted? Now, if you look at this, if you look at what has been discussed in the passage, this clearly relates to the time period. So when did this happen? Let's say 2020, and now it is in 2022. So in the passage, it was given if it is more than 1 year, if the gap is more than 1 year. So what is given to us in the passage? After the expiry of the period of 1 year from the date of commencement, unless the Commission of Food Safety approves prosecution within an extended period up to 3 years. So if you look at this case, the first part, it satisfies the first principle, but the second principle or the second criteria, it fails. What does the second criteria says? Subject to the condition that he has to record reasons for doing so. So did he record? Let's look at this one. By the Commissioner of Food Safety over a lengthy telephonic conversation. Right? But was it recorded? Not given. From the information, we can safely infer that it was not recorded. And therefore, the answer would be D. The answer is this case would be D. Which of the following goes against the principle as discussed in the passage? Let's look at A. When an offense has been committed by a company, every person who at the time the offense was committed was in charge of the company for the conduct of the business of the company shall be deemed to be the guilty of offense. Now, yes, given, and this is as per food and safety standards. So I will still keep it because this is more of a generalized thing, but it is given, though it is in a particular scope of Food and Safety Standard Act. But let's see. In a criminal law, there is no concept of vicarious liability. And it is only if there is a statute which makes a person, yes, this is given, right? So this does not goes against, so this is definitely out. Now, the existence of section 66 in the food safety standard is a clear pointer to the fact that the criminal prosecution can proceed against without arraigning. No. In the passage, it was given that is a clear pointer to the fact that the criminal prosecution cannot proceed against partners without arraigning. So this is a clear-cut winner, guys. So I was confused with A, but C is clearly contradicting what is given in the passage. So for me, the answer in this case is C. Okay, now ABC is a company and looks over the day-to-day operations of the company. All right, Mr. Ryu is a technical head of the company and reports directly to the board of directors to their website and other digital outreach. X and Y are in charge of IBID plant and report directly to TK and are supervision of the plants in IBID. FSS Act, ABC has already been arraigned. So company has been arraigned. So now you can proceed against the employees, against the partners. Decide who all are liable. So in the passage, it is given to us that was in charge of and responsible to the company for the conduct of the business of the company. Now, in this case, all of them are responsible for the conduct of the business other than Mr. RIU, because he was only responsible for the website. right? So not for the conduct of the business per se. So any choice which has Mr. U should be out and everyone else should be there. So Mr. TO is there, Mr. X, Mr. L, Mr. M, and Miss Y, all of them are there, and Ryu is not there. So this is the correct answer. So for this, the correct answer is D.